Good evening, everyone. And thank you, Kanika, for that nice introduction. And thank you, Wolters Kluwer, for inviting me to speak on a very interesting subtopic today. And we all have gathered on a Friday evening to listen to these trends and transformations in arbitration. I'll also touch upon the shaping up of the future of justice delivery system in India and what are the global challenges which we are facing. If you talk about the trends in last 1 decade, we have achieved a lot in terms of shaping up the future. Because unless and until we change, the change is the constant, we will not be able to secure our future for the next generation. And what really we have achieved is what Mr. Pachnanda said is a three-pronged approach. One is with regard to strengthening our legislative system. So we amended our legislation to ensure that whatever the loopholes or any criticism we have about India about excessive judicial intervention into the arbitration process, we have achieved to a great extent in last 10 years to remove that, because we had number of judgments of the various courts in India to kind of slow down the pace of arbitration. The biggest criticism which we have when we go out of India and within India is that arbitration takes very long time and it never ends. So we have put the timelines in place now. We have ensured that the courts don't reappreciate the evidence. We have defined the public policy of India, which is again a concept which is known internationally, but the Indian courts had interpreted it very, very differently. So those are the pro-arbitration approach we have achieved in courts. If you see, Indian courts have also appreciated that the arbitration system has to be left on its own, and unless and until there is a need to intervene, the arbitration should work itself out. So that's something we have achieved by sensitizing the judiciary in the right spirit. We also have now the judiciary who is supporting the arbitration and also trying to expedite the process of reviewing the awards at the time of setting aside or enforcement. Now, the biggest challenge we are still facing is the enforceability of the awards, because unless and until we have an award which is enforceable, the paper award has no value. So ultimately what we need to achieve, and the biggest goal we have to achieve altogether, is to ensure that the awards are enforceable. Awards can be taken to the court as if it's a check which can be encashed, and then we have to get the fruits of our arbitration. For that, getting the timely interim relief is also very important, because if you don't have the subject matter of the arbitration preserved, it will be very difficult for the enforcing court to enforce the award, because once the award comes, if you start searching for the assets, it becomes very, very difficult to then find the assets which can satisfy the award. So getting the timely interim measures are extremely important, and also having an enforceable award. And for that, what we have done is that we have put a condition to deposit an awarded amount in the court if you want to challenge the award, if you want to get a stay of the enforcement of the award. So that is a positive development. We have seen that many parties settle and not litigate any further when it comes to the challenge of the awards are concerned, and it helps the enforcement. Now, talking about government and public sector undertaking, which is the biggest litigator in terms of the arbitration or mediation, and Mr. Mishra is here. He says he has 52 live arbitrations. You can see that what has happened is that every project goes into dispute, and that has become like a trend for our arbitration regime, is that if you have any construction dispute or any government dispute which has the public-private partnership, it goes into the dispute, and we have to avoid it by using various alternative means to arbitration. And arbitration is the only mean, and we can't go to court for this dispute. And surprisingly, the government has come up with a circular which says that the public procurement contracts, they don't want to go for arbitration and mediation. It is a welcome step to that extent, but we can't avoid arbitration, because if you can't resolve through mediation, then the only option which remains is arbitration. Of course, there is a criticism that arbitration takes long, but we have achieved a lot in terms of the trend which we are seeing. The other trend which we are seeing is also focus on a specialized arbitration practice. Just few months back, we have set up Arbitration Bar of India, which is a great initiative which we have achieved to consolidate the arbitration practitioners in India who can then give focus to the practice of arbitration. The purpose of setting up the Arbitration Bar of India is to give a voice to the arbitration practitioners, also give them training and also do capacity building. We need to increase the pie of the arbitrators in India, and we don't have to rely on the former judges to sit as an arbitrator. We in in-house counsels, we can have practicing lawyers or independent arbitrators, senior counsels who can sit as the arbitrator, and ultimately the goal is to achieve the desired result of the award within a stipulated time in a cost-effective manner. And for that, we have to increase the pool of arbitration, so the training is very important. Focus on a arbitration practice is also very important, because now we see the younger generation who are joining us in law firms or otherwise, we see that they want to specialize in arbitration. 10 years back, we were finding it difficult to attract the talent to do arbitration because they say that they are not visible in the court system, because that is the biggest, for a litigation lawyer, visibility matters a lot, because if you are seen in the court, then only you are a litigating lawyer. But for arbitration, what are the advantages? We have the fixed time for arbitration. You start on a particular time and finish on a particular time. You know your calendar. When we are appointed as an arbitrator, for example, in ICC matter, we have to give the calendar for the next 2 years to ICC to ensure the availability. Now, the biggest challenge we are facing also in arbitration is availability of the busy arbitration. So, we need to increase the pool of arbitrator. We need to increase the pool of the counsels who are practicing on the arbitration side and be available full time Monday to Friday to do arbitration. Then only we can reduce the backlog. When it comes to the court system also, we need specialist judges who are trained into doing the arbitration practice, and rather than having a kind of a rotation, we should have the bench or arbitration bench. Delhi High Court is a classic example. We have 3 or 4 judges or the courts who are doing exclusively arbitration in addition to the IP division. So that is a great model which the other courts should also follow and try to ensure that the focus is only on arbitration rather than mixing the arbitration matter with the other matters. Ultimately what we want to achieve is that the best practices should be adopted. Now, technology is an integral part of any arbitration process. We saw about the data management. We have to also ensure that technology is used for production of documents, because that takes away a lot of time in any big international arbitration, because the documents are voluminous. So we can use technology to our advantage for document production, for transcript, for translation. And also with regard to the hearing, which we can do virtually across. So technology is there, and I'm sure Neha will take us through in the next session, next speech about the use of technology in arbitration. We have also reduced the appeal process in the arbitration. We are trying to, for example, in the international commercial arbitration, if you have foreign award, those awards are enforceable as if they are the decree of Indian courts, and that also helps India to ensure that we are part of the New York Convention. We have been enforcing the awards, and seeing that we have the trend of attracting the foreign investment into India, because unless and until we create the confidence into the investors, we are not able to get India at the forefront on the dispute resolution front. But contract enforcement, we have to focus a lot. The great initiative we have in Gujarat is the Gift City, which is modeled on various other special economic zones. We are going to set up the world-class international arbitration center, and eventually the plan is also to set up a international court in India, where we can invite the foreign judges to sit on the arbitration side and decide these issues. Of course, there are certain issues with regard to setting up the court, which is not part of the judicial hierarchy in India, but we are working on it. So these are the issues which we are aligning with India with the best practices across the world. And third party funding, for example, if you talk about in other jurisdiction, third party funding is very, very prevalent. Of course, there is no prohibition in India with regard to third party funding, but what we are seeing is that a legislative recognition of third party funding or any kind of recognition apart from the judicial pronouncement, if we can have, that will boost the process of third party funding in India, because there is nothing wrong in any third party funding the arbitration. That will really bring some kind of discipline in the process of arbitration, only because if unless and until you have a merit in the claim, nobody is going to fund that arbitration. We are raising a lot of frivolous claims. I'm sure as a public sector undertaking, we see many contractors, they raise the claims in crores or billions of dollars, which essentially are not, they are not eligible to do it. It's a part of their process to perform the contract that the dispute is also part of the performance of the contract, because unless and until they have dispute, they cannot make the additional money which they are suffering the loss. So third party funding will bring a lot of discipline into the process of arbitration, which we have to achieve in the process of arbitration. Now, there are other best practice also which we should adopt, is drafting of the arbitration clause. We sometimes don't pay enough attention to the drafting of the arbitration clause, because unless and until we have a robust arbitration clause, the best way is to go for institutional arbitration, because it brings in a lot of advantages. India has some of the best institutions now. We have India International Arbitration Center, we have Delhi Arbitration International Arbitration Center. In Mumbai, we have FCIArb, which is there. Globally also, there are institutions like SIAC, ICC, LCI, who are very, very active in India, and we all are some form or the other associated with it. Chartered Institute of Arbitrators also provide a very good training for the arbitrators. So whosoever is interested in sitting as an arbitrator should undergo the training, irrespective of their background. It doesn't matter. So these are the best practices all of us we should adopt. When we start the arbitration also, we should adopt the best practices. There are certain soft laws. Now IBA has come up with the guidelines for taking evidence in international commercial arbitration. Those can be adopted. These are all time-tested rules which can be adopted to streamline the arbitration, which will really reduce the time and cost for the arbitration. Also, early dismissal of the claims. We are now in process of revising the SIAC rules. I am member of the Court of Arbitration of SIAC, and we are trying to ensure that how the rules are adopting the new methodologies of reducing time and cost in any arbitration. Because what is the ultimate goal of a party? That they want a resolution in a speedy manner at a minimum cost. And if we can achieve that, and the institutional cost, even if it is incurred by the parties, experience shows that overall the cost gets reduced, because you have certainty about the rules, you have certainty about the fees of the arbitrators. Because in ad hoc arbitrations, we see that the fees of arbitrators becomes a very big issue, because there is no fixed fee which we can ask. Of course, there is Schedule 4 in our Arbitration and Conciliation Act, but hardly that is followed in international commercial arbitrations. We also can use expedited procedure, not to have oral evidence when it is not necessary. And also presenting the case, Mr. Pachnan has already relied heavily on written advocacy. We focus most in India about oral advocacy, but written advocacy is also very, very helpful. So if we adopt this particular best practices and also ensure that we have the court system in place in India, India can definitely become the destination for international commercial arbitration as a neutral venue where there are two parties who have nothing to do with India can come to India and arbitrate. That's the dream which we have to achieve in India, because foreign law firms are there, we have to compete with them, and we have to use technology. And there my experience with Kluwer arbitration is also very, very helpful, because I was arguing a case in a Singapore seated arbitration, although governed by Indian law. The question came from the arbitrator is that for grant of interim measures, what standards we should follow? We should follow the Indian law or a Singapore law, because it's a question of procedural aspect. It's not a substantive law of the contract. when we do international arbitration, a lot of laws get involved in that. And we have to show the jurisprudence. We showed the jurisprudence from our research, and the Kluwer arbitration resource is very, very helpful. Our entire team is using it to show that the standard set out under the Singapore law and the cases under the Singapore law and Indian law is the same. The principle is that you have to show prima facie case, balance of convenience and irreparable loss. In whichever way you look at it, if you are asking for a mandatory injunction, even Singapore law in so many cases have relied upon the very same principles which are followed in Indian law. And interestingly, the party who was asking this interim relief from the tribunal had approached the Indian court first under Indian Arbitration and Conciliation Act to get an interim relief. They failed there. They filed an appeal. The appeal court said that you go to arbitral tribunal and ask for the relief. The question came up is, can an arbitral tribunal can sit over appeal against an order of the Indian court? And those were the complex issues. We could find a lot of judgments on that aspect on the Singapore law, and it's on our fingertips, and it's so easy to use. So we are very happy with the Kluwer arbitration support. There are a lot of database and the research material which is available there. With this kind of technology and the use of material, we can be the best lawyers across the world, because I was talking just before this, that India before the session with one of the guests here, is that India has the unique advantage of being English speaking, common law, experienced lawyers, and also trained internationally. We have so many of us are trained outside India and practicing in India. So we need to get the best practices to India and fight with the challenges. Nobody can beat India if we put our act together or put our house in order. There are very few things which we need to achieve. We have achieved a lot, but if we do something little bit more, we can achieve all the requirements of making India as the best destination for arbitration and meet with any kind of global challenges on arbitration. And lastly, we have to use mediation. For commercial dispute resolution, we have to use the hybrid model of mediation and arbitration. We have now Mediation Act. We are also getting trained. We need a large pool of mediators who can resolve commercial disputes, and that's also going to be a parallel dispute resolution system along with the arbitration. So with arbitration and mediation hand in hand, we can definitely provide a solution for all our investors who want to come and invest in India without any fear of the contract enforcement. With that, I will end my speech. Thank you so much. Thank you.